All right, this is just We the People News. I'm going to kind of keep my little thing short. So, there is 5 elements in the Fourth Amendment, and they all must be green lighted by the magistrate to order to issue a warrant. Anything other than that is a violation of the Fourth Amendment. All right, absent of affidavit under penalty of perjury. All right, is one of them. And we've been such creature of habits that we've been letting them slide with it, and they've been using uh, information against you, and and magistrates are blindly signing things under information and not as an affidavit. There must be a claimant. There must be a witness under affidavit, or that warrant is null and void. All right, so I know that you don't want to take my word for it because I'm not an attorney and I'm not giving legal advice. And if you have money, donate to these people. They're doing fine work out there, okay? Institute for Justice. And you guys know how I am about attorneys already. I don't need to go any deeper in that. So when I say donate to these people and they're doing good work, it's because these attorneys are actually good. Do I believe in everything they do? No. Okay, there are certain things that, uh, they're doing. I'm not even going to go that far. But as attorneys, I am led to believe and do believe they are for the people.
There's a warrant before police can search you or your property. But what if that warrant...
Let's go start from the back and go.
The Constitution requires a warrant before police can search you or your property. But what if that warrant is based on third-hand information? That's what happened to IJ client Michael Mendenhal, who was arrested for asking an unruly trespasser to get off his own porch. I'm Kim Norbert of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely and IJ attorneys Patrick Giacomo and Jared McClain. We'll discuss how warrants are often just rubber stamps and what IJ is doing to fix that. This is Beyond the Brief. So Patrick, as a starting point, can you just give us a quick overview of how a warrant is supposed to work?
Yeah, so warrants are supposed to be a check on executive power, and they require a neutral third party, usually a judge or a magistrate, to look at evidence that's submitted and determine whether that evidence supports probable cause to issue a warrant, which then allows, usually police, to search or seize something. So maybe arrest someone, that's a seizure. Search, of course, look for things inside of a home. And the real idea that's captured with the warrant process is that you're supposed to have a dispassionate third party to evaluate the credibility of the underlying facts and whether they support the belief that there might have been a crime committed.
So how did that whole process go awry for Michael Mendenhal?
So for Michael Mendenhal, the process went awry because the warrant, which was submitted by a police officer, didn't provide any firsthand information that that police officer saw. What the officer told the judge in his application was, I swear that a guy told me that a guy told him that Michael did something. And so based on that sort of attenuation in the game of telephone, then the judge who's issuing the warrant has no ability to probe the credibility of those facts. And if the judge had, in a case like Michael's in particular, the strange man that was the ultimate witness here clearly would have raised red flags for the judge, but the judge didn't get that. Instead, the judge got something that had been sanitized by 2 levels of police officers telling police officers who were then swearing to the judge.
So for some of y'all that's been in that branch of the going through the system, does that or does that not sound familiar to y'all? Because Texas is really victorious at this. And again, that's the reason why they violate Criminal Code 14, 15, 16. And Transportation Code 543 is because they are ignoring the Fourth Amendment by using information.
Let's talk a little bit about the facts of what happened to Mendenhall that night in Denver.
Yeah, so Michael is a business owner, and his office is in a townhouse in downtown Denver. And at the time, he and a friend were setting up this new townhouse to be this office. And it was about 10 p.m. at night. It was dark. They were just relaxing after the long day of putting things together when they heard a commotion outside, such that people were shouting, and the front doors of the townhome were actually kind of jostling. So, it's dark outside. Michael wants to go investigate, make sure that these women are okay. He walks to the front door, looks out, and grabs what's sitting next to the door, which is a commemorative all-star game baseball bat that's signed by baseball players. And he opens the door to find some strange man he doesn't know with a dog who's in the midst of some sort of discussion with these women who don't seem interested, and tells him to get the heck out of there. And then he closes the door and goes back to doing what he was doing. And as far as he was concerned, that was the end of the story. But unbeknownst to him, this man then went and called the police and said that Michael was menacing him with a baseball bat, and the police showed up, and he told them this very strange story about how he lived 30 miles away, but he was just there because he needed to go for a walk, and he volunteered that he had a loaded gun with him. And it was all very strange and didn't add up. But nevertheless, this information ultimately led to not only Michael's arrest and a night in jail, but the search of his townhouse and the seizure of his all-star bat, which the police still have to this day.
So wait, was it Michael Mendenhall who said that he had a gun, or was it the guy who he threatened or asked to leave?
The strange guy had the gun. Yeah. So that adds to the weirdness of it all. There was no concern for his own safety because Michael had the All-Star game bat, and this guy apparently had a gun. So it's all very weird, and it's all something that I think even on the sidewalk at 10:30 at night, you would be making the same face you're making at me right now.
It's a bizarre set of circumstances, and police did no investigation before essentially arresting Michael Mendenhall. Is that right?
Right. So the police just took this guy's word for it. He came and handcuffed Michael, put him in a squad car where he sat for, the time that it took them to then call in, tell the detective what had happened. The detective writes up the third-hand story and then submits it to a judge who ultimately signs off on the warrant that allows the police to then enter and seize the bat.
So what specifically should have happened? Because if something, weird happens to me and, I call the police later. I've never called the police in my life. But, if I call the police later and say, hey, such and such happened, I'm concerned about it, what you described kind of sounds to me like what I would expect to happen. So what's the kind of missing piece?
Well, so unfortunately what I described to you is often what happens in most cases. Now anymore, police will simply write an affidavit where they say, I swear that somebody else told me. And maybe it's just that attenuated, or maybe it's someone else told me that someone told them that someone told them. And unfortunately, that is the state of affairs for the warrant process today. But originally understood, the Fourth Amendment required a warrant that's supported by oath or affirmation. And the oath or affirmation that had to be given was understood to mean you have to have a witness with firsthand knowledge who would be swearing to the facts that would then support the warrant.
But this guy had firsthand knowledge, right? So is the problem just that they didn't have him sign an affidavit?
Right. The problem is that this guy, the actual witness, the stranger here, is not the one who's going to the magistrate, whether that's in writing or orally, to say, here's what happened and why there should be a warrant issued. And if he had, then not only would the judge be able to probe the credibility of the witness, but also when things turned out to be wrong, as they were in Michael's case, he would be held accountable because he would have sworn something falsely under penalty of perjury.
So, Jared, we've seen at IJ kind of many situations where the government's sort of acting on baseless information or hearsay and then does harm to a client by, wrongly arresting them or having their house raided or other things like that. Can you talk about some of those instances?
Yeah, so it comes up a lot in our retaliation cases because there's often no reason to be arresting our clients in these retaliation cases in the first place. And so when someone's arrested for no reason, the first thing you usually do is say, well, there's no probable cause, and they shouldn't have been arrested because there was no evidence that they'd done anything wrong. And what gets the argument that we have to contend with at that point is, okay, but a magistrate signed a warrant, and that is as strong evidence as you can have that there is probable cause. And so now we're like running into this fact that there's a warrant, and what do we do about it? Because we know our clients didn't do anything wrong.
What do you mean by probable cause?
So probable cause is just that it's essentially more likely than not that a crime had happened. The police have enough evidence, enough reasons to believe that this specific person committed this specific crime. And what they're supposed to do is go to a judge and present that evidence and say, we have a really good reason to believe that Sherry Digman in Atmore, Alabama, or Cynthia Jackson in Atmore, Alabama, or Ruth Herbal in Marion, Kansas, that they committed this crime, and we should be able to search their house, we should be able to seize their cell phone so we can look for more evidence so we can prove that crime in court and eventually arrest them and charge them.
Right, and built into these concepts is that the warrant provides this very probing, violative action by the government. And so we want to make sure that before we give the government this awesome power, there's a good reason to do it. And so the process of the warrant being given is supposed to be a way for the executive to go say, I want to do this invasive thing, and then have a neutral, the judiciary, say, okay, it's justified in this case, so you're not deciding yourself whether you can just go off and do the thing. And so when we're eroding these concerns, what we're actually doing is taking away a check on executive power.
And the problem I think that creates is...
And hence the reason why you're supposed to be directly to the nearest magistrate to get that probable cause and make sure everything is, with that Fourth Amendment, all green lights, all 5 elements fit. The affidavit of the witness that has firsthand knowledge, the complainant, and you to be seen by the magistrate before you go to jail to make sure all the ducks are in line and an innocent person, loosely person, is not going to jail that night or for 24 hours or 72 hours or anything. So even on TV shows, they're misleading you about holding someone for X amount of time. It's false.
The courts aren't really treating it as if there's been any erosion. So the courts are still treating these warrants like a judge has looked at all this evidence and tested the witness's credibility, and there was an oath or affirmation. So they have every reason to trust that this crime happened. And so then when we're coming in after the fact to say, hey, there was no evidence of the crime in the first place, the police are like, well, we were entitled to rely on a warrant. A judge signed off on this, so how are we supposed to know there was no probable cause? That's the judge's job to figure it out. But the judge was relying on this hearsay or this like third-hand or fourth-hand information, so there was never evidence in the first place, but then the validity of this investigation gets baked into the fact that a judge signed off on a warrant without a proper oath or affirmation in the first place.
Yeah, and fundamentally the problem today is that this warrant process, which the founders designed, as I said, to be a check on government abuse, has now, as Jared's explaining, become a mechanism to launder accountability. So in the beginning, this was meant to be a serious bulwark against the government doing whatever it wants, but because of several different doctrines that have stacked on top of each other, today it means if you get the warrant, you're good to go, and there's basically no way to challenge it, even if you're the victim who didn't actually do anything, if there wasn't even probable cause for them to believe you'd committed a crime.
So let's start to walk through that a little bit more granularly. I know that this case is about the oath or affirmation requirement. How did we get from, at the time of the founding, oath or affirmation means personal knowledge, sworn under penalty of perjury, to today's oath or affirmation, which apparently means if someone told me that this happened, I can write it down and I can do what I want with it?
Yeah, so it's actually a pretty simple story, and we should start with the text of the Fourth Amendment, which of course was something that the founders put into the Constitution because one of the things that we were concerned with were violations of people's rights under things like general warrants, where the king's men would just be allowed to come in and break open whatever they wanted. As you can imagine, the colonists didn't like that very much, and relying on some cases like...
Have you guys heard of general warrants today that we're not supposed to have?
Epic versus Carrington, they drafted the Fourth Amendment, which says, no warrant shall issue but upon probable cause supported by oath or affirmation. And then it talks about specificity required for where the warrant can be executed and against whom. But you see, like, there are several components that are laid out in the text. And so the question becomes, what happened to the oath or affirmation thing? Historically, for 150 years, courts understood that to mean firsthand knowledge from the witness. And I think that's embedded in the language oath or affirmation. It's just kind of strange when you step back outside of the world that Kim described today, and you just think about swearing an oath. Can you swear that something happened or that something is true if all you're swearing is it's true that Keith told me something? Sure, that's I'm swearing something, but it's not to the substance of the underlying issue, which is the probable cause here. And so the way that we got to where we are is that police started using confidential informants in the mid 20th century, and I think it's simply a matter of convenience, although there's not much discussion. The Supreme Court, in a case called Jones versus United States, said that that was fine. And it did that without really getting into any analysis about oath or affirmation. It was just a question of whether relying on secondhand confidential informant information was sufficient under the Fourth Amendment. And the Supreme Court said it was. And since then, this has just spread to the point where now...
Which that case right there violates the Fourth Amendment as well, and the Fifth Amendment, and the Sixth Amendment. Because now you're allowed to face your accuser, but that court case is saying, oh, well, no, they're special. They're special. So they don't have to come up, and that would cause a disruption in their cases for you in the future and all that. But they don't do that, and again, that's violation of the Sixth Amendment.
Kind of such a pain to bother getting someone to sign their own affidavit that police often dispense with this.
There's two things that you said there that I think that we should dig into a little bit more. The first is the aspect of confidential informants. As I understand it, in order to have the oath and affirmation requirement satisfied, that informant would have to either appear in front of the judge or, sign an affidavit, somehow fill out a thing. Wouldn't that compromise that person's security in some sort of, dangerous situation where they're surrounded by a criminal ring and whatever? Wouldn't that put them at risk of being exposed?
So the other thing that they can do, besides they could sign something, swear it out on paper, and have their name redacted. And as long as the judge under seal or in camera reviews that and thinks there's sufficient reliability, the judge could sign off on a warrant on that basis. But the judge can also just talk to someone either in person or on the phone and take their oath that way. And so we had a case in Marion, Kansas, a retaliation case where the signature of the affiant was just missing. And we're like, well, there could have been no oath or affirmation because there's no signature here. No one even swore off on this. And the argument from the other side was, yeah, but the judge called the police chief. That's like, you can get around filling out an affidavit by just picking up the phone and talking to a judge. And with modern technology, there's not really an excuse anymore. This isn't like the 1700s where you got to put someone on horseback and bring them 40 acres to find the judge in the middle of the night and knock on the door. We have enough technology that people can DocuSign, they can pick up a phone. There's lots of ways to accomplish it.
The other thing to keep in mind is, and the threshold is much lower at the probable cause stage, but ultimately if someone's testimony is going to be used in court, they're going to have to show up to court. You can't anonymously be someone testifying in court. And so, as I said, there's a difference between getting the probable cause and ultimately getting there, but it's on the same continuum. And so the thought of arresting someone based solely on something that will never be allowed to come into court seems problematic in its own right.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
The other aspect that you kind of both have talked about at this point is convenience. And on the one side, Jared, as you were explaining, it sounds like it's pretty convenient still for the government to get a warrant. There's all of this technology and things like that. Doing it correctly seems not that hard, honestly. Right. But I could also imagine that the government in cases like this is going to say, oh, well, we can't be bothered to, clear all of these boxes in this rigorous way because, there's a lot of technology now and things move quickly and we have to be able to, whatever, who knows. And so how does that sort of balance out? Is there a legitimate concern here that this is overly burdensome of an expectation for the government?
I think
All right, we're going to go ahead and pause the